Good afternoon, everyone, and thank you so much for being here today. My name is Rebecca Joseph. I am the editor-in-chief, the outgoing editor-in-chief of our Ohio State Journal on Dispute Resolution here at the Moritz College of Law. It is my pleasure to welcome you all to this year's Schwartz lecture on dispute resolution given by Professor Deason. This year is special for me because I got to be in Professor Deason's final 1L civil procedure class before her retirement. So we're just so thankful that you continue to be engaged with the program and that you continue to put forth work and that you're here today. So thank you for that. Before we get started today, I also want to read the university's land acknowledgement. We would like to acknowledge the land that the Ohio State University occupies is the ancestral and contemporary territory of the Shawnee, Potawatomi, Delaware, Miami, Peoria, Seneca, Wyandot, Ojibwe, and Cherokee peoples. Specifically, the university resides on land ceded in the 1795 Treaty of Greenville and the forced removal of tribes through the Indian Removal Act of 1830. As a land-grant institution, we want to honor the resiliency of these tribal nations and recognize the historical context that has and continues to affect the indigenous peoples of this land. Thank you. Before we get started, I want to pass the mic over to Dean Lincoln Davies. This program, our program on dispute resolution, and all of the events and scholarship that flow from it would not be possible without your continued investment and partnership. So thank you so much. And with that, I will pass the mic over to you.
Welcome everyone, both here in Saxby Auditorium with us and in the internets, such as they may be. Welcome to the Schwartz lecture in the pandemic world, although I think rapidly we are exiting that world, much to everyone's delight. So it's a pleasure and honor to be here today. I want to thank Rebecca Joseph both for the introduction, but even more so for her tremendous leadership in the Journal of Dispute Resolution. They successfully recently completed the symposium, which was just terrific, and rethinking system design from a dispute resolution perspective to address racism and equity and justice. And I couldn't think of a more timely topic and a more important one. So many thanks to her for her leadership and everyone in the journal. It's also a pleasure to be here today and to acknowledge the continuing support we have from our alums and supporters of the college, including Arthur Schwartz Jr., who was the namesake of this lecture, class of 1947 member, and made this lecture possible. Throughout the years, this lecture has added to the discipline of dispute resolution, to the scholarship in the area, and to the scope of the field. And today's lecture certainly will be one more entry in that regard. As we think about what the lecture will be today, I couldn't be more excited because three things come to a confluence. The first is that, consistent with what we've always done with the Schwartz lecture, we bring today a renowned scholar in the field. But it's also a great pleasure that we've also brought a dear colleague and a wonderful friend, Professor Deason. So we're really excited to hear what she has to say today. Before I say a few more words about Professor Deason, though, I also want to acknowledge and thank our dispute resolution program, #1 in the nation. I think that deserves a round of applause. So many of the faces here in the crowd who engaged in that program, whether they be the current director, Professor Katrina Lee, or the former director, Professor Sarah Cole, our brand new star who we are already in love with, Professor Amy Schmitz, who joined us this year from Missouri. Professor Deason is here, Professor Dean Emerita Rogers, Professor Stolberg. The list just goes on, and you can see why we're #1. So let me turn to Professor Deason for just a moment. Her academic history reads sort of like a stat sheet for an NBA All-Star. I think is maybe the best analog. You just sort of go down the list, writing path-breaking scholarship, helping write uniform laws that have changed the way that dispute resolution is practiced in the world. Having won our Morgan Shipman Teaching Award here at the law school, our highest teaching honor, and having won the university's Distinguished Alumni Teaching Award, the university's highest teaching honor. It goes on, and it doesn't stop there. Clerkships at the highest levels, including the United States Supreme Court. A beloved teacher, Rebecca noted her civil procedure course, just a delight and a favorite of all of our students. But Professor Deason's not one to rest on her laurels, and her scholarship really has transformed the field of dispute resolution, reaching from civil procedure and litigation all the way to mediation. And she'll be speaking today on a topic of mediation because she doesn't rest on her laurels. She continues to have that inquisitive mind and to try to press the field forward, a hallmark of what we're trying to do here at Ohio State. So her talk today will be on mediation, questions through the lens of equity, bringing to bear ideas of anti-racism and how to move the field forward. And with that, please welcome to the podium Professor Ellen Deason.
And I'd like to thank you both for those really warm words, and extend my deep gratitude to the Schwartz family, not only for the opportunity to deliver this lecture, but even more for the lecture's ongoing contributions to the life of the college. And through the annual publication in the Journal on Dispute Resolution to the entire field of dispute resolution. I've enjoyed the enriching experience of the Schwartz lecture during my almost 20 years at Ohio State. And it's been wonderful to be at an institution that takes dispute resolution seriously and its importance in preparing students for the legal profession so seriously. And a major benefit of that institutional commitment has been the opportunity to interact with so many wonderful colleagues over the years. Dean Davies mentioned many of you. I want to give a special shout out to Bill Froelich, who is the reason that we are in a hybrid mode with this funny looking owl that you online can't see, but is what's bringing me to you. I look out at the audience, and I appreciate the students who are here today and the members of the local dispute resolution community who add so much to our program through their enthusiastic support. And this year, it's a real pleasure to welcome colleagues from across the country tuning in thanks to modern technology. You are a group that is both supportive and stimulating, and I appreciate my many interactions with all of you. Now, lastly, I want to thank my co-author and companion on a journey of reflection and discovery. Where do I go? There. Sharon Press of Mitchell Hamlin Law School. And our work together has stimulated thoughts that I will be expressing in this lecture today, which I hope we will develop together into an article. Although I have to say that at this point, I'm not sure that Sharon agrees with everything that I'll be saying. So as some background, let's see, do I have to aim this here? Anyway. Let me tell you about what led to this collaboration. After George Floyd's murder in the spring of 2020, Sharon and I both enthusiastically joined a reading group that was put together of dispute resolution colleagues to read and discuss this book, Layla Syed's Me and White Supremacy. And the title is Combat Racism, Change the World, and Become a Good Ancestor. And her book leads the reader through a series of personal reflections and projects that we do each week. And our group met weekly to discuss our reactions. Now, this was a process of personal growth. And I do recommend the book to all of you. It's a nice change from scholarly things, although it has plenty of meat in it. But in addition, Sharon and I saw some of the concepts in Syed's book as being relevant to our work in mediation and to the way that process is structured. And so we wrote an article focusing on the structure of mediation and raising questions about the role of white supremacy. we purposely don't offer much in the way of answers. Our purpose here is to stimulate discussions about this issue. But my observations today will build on this work. So let me start with the word equity. Before I turn to some of the concepts in Syed's book, let's focus on this third definition here. It contains a pretty good description of the original development of the branch of judicial system called equity. Some of you thought you were not going to have to deal with any civil procedure today, but let me disabuse you of that assumption. So it's a body of legal doctrines and rules developed to enlarge, supplement, or overrule a narrow, rigid system of law. And that rigid system would be the common law of England. And so after William the Conqueror did his conquering, and there he is in a famous statue that ironically I think is in France, not in England. One of his contributions was to unify the legal system of England, which had been entirely local. And so he sent the king's judges out to hear cases and create consistent legal rules. And I'm emphasizing consistency here. And over centuries, this became the common law, with its emphasis on precedent and treating like cases alike, which we in the United States inherited. So under the rigid system of common law writs, there were many who couldn't get a remedy, and they began to petition the king. This evidently became tiresome because he delegated those cases to the chancellor, who sat in chancery court. And here is a picture of one of the most famous of the English chancellors, Sir Thomas More, who served from 1529 to 1532, and that gives you some sense of the time frame. Today, the two systems are merged. I want to stress two things about the original differences between them. First, the remedies in equity went beyond money damages with measures such as injunctions, specific performance, and this was so that equity could provide relief in situations where money damages were inadequate. And second, the equity system took more account of individual circumstances. This created some flexibility in the outcome, and while I don't want to overstate this, it's credited with paying more attention to the principle of fairness. So let me illustrate that flexibility and attention to circumstances with the way the two systems treat delay in filing suit. In common law, the limit on delay is a statute of limitations. It's a matter of time, and it specifies a time that determines when a claim is cut off. And here's an analogy that I think I first heard from Michael Moffat at the University of Oregon, that you could say the statute of limitations is like an expiration or sell-by date. From the perspective of a grocery store, this is a cutoff, and they start reducing their prices to get their milk sold. Now, in contrast, in the system of equity, the doctrine is laches, much more flexible. And here the judge will decide if the suit should be dismissed, looking at several factors. Did the plaintiff reasonably delay, or was it unreasonable? Was the defendant prejudiced through loss of evidence, perhaps? It's a matter of discretion, and it's dependent on how the judge sees the actual circumstances, not a predetermined length of time. Now, in our house, we use laches. The date on the bottle is not irrelevant, but it doesn't determine if we drink it. I think of the smell test as being a functional analysis like the ones used in an equity case. Okay, so why this excursion into civil procedure doctrine, other than that I have to live up to the introduction? I'd like you to consider the parallels between the development of the equity system and the growth of mediation in recent decades. Mediation is often intertwined with litigation, but like the equity courts, it has introduced new forms of flexibility into the system. Litigation on the right, characterized by rule orientation. And that assumes that disputes can best be resolved with a general rule of law, consistent rule of law. And it is very common for lawyers to regard those rules of law as the best measure of fairness and equity. But from a dispute resolution perspective, this orientation reduces the richness of individuals' concerns to legal definitions and binary win-lose results that are based on general principles that don't always work in the actual situation. One way that mediation, which is summarized on the right, go back please, is that parties don't have to follow the law. What they think they are entitled to under the law is often where they start, but they can agree on an outcome that is different from what they would or even could receive in court. So like the equity system did originally, I see mediation as expanding the options available to the parties. And second, again, similarly to equity, mediation allows for a more individualized treatment of a dispute. The parties can shape the outcome to fit their own needs. And the process can take into account other things, such as the future, social, psychological, political, moral dimensions of the issues, and not just the legal aspects. So one can see both the equity system and mediation as increasing the responsiveness and the flexibility of the existing prevalent processes for dealing with disputes. Now, what does all of this, you're wondering, have to do with fighting the consequences of the racial divide in our country? Here's a quote from Carrie Menkel-Meadow that suggests an important role for the flexibility of expanded options and individual treatment that mediation offers. Settlement and its sometimes rejection of law can be seen as an expression of individual justice, where rules made for the aggregate would be unjust or simply irrelevant to the achievement of justice in individual cases. Now note the emphasis here on justice. This takes us to a different sense of the word equity as fairness or justice in the way a person is treated. This usage has become prevalent in recent years and in many institutions. We now have diversity, equity, and inclusion offices rather than just diversity or D&I. Equity, in this sense, is to be distinguished from the concept of equality. And we can date this distinction back to Aristotle. He called them both equality, but he differentiated between two types of equality: numerical equality and proportional equality. His principle was that like situations should be treated alike. And when that condition prevails, then it is fair to provide individuals in that situation with equal resources or equal treatment. His corollary, though, is that when situations are different, equality in the sense of proportional equality means treating individuals differently, taking into account their situation. And I think this roughly corresponds to what we call equity. Now, many of you have seen variations of these pictures to illustrate the difference in the concept. On the left, we have, your left, equality. Each child has an equal resource, one box to stand on, but only one child can see comfortably over the fence. A more equitable distribution of this resource on the right gives two boxes to the short child, so she can see over the fence just as comfortably as her tall friend. But any number of boxes are going to be useless to the child in the wheelchair. So he gets a different type of resource entirely, not just more of the same of what everyone else got. And he has a ramp that he can roll up. Now note that this illustration is about equity in the outcome of the resource distribution. In the equitable situation, the outcome is that all the children can enjoy the game with equal ease. For mediation, and in this talk, I would like instead to focus not on equity and outcome, but instead on the possibility of equity in the process. Can we even imagine what that principle might look like? One place to start, I think, is where things may feel inequitable to some participants. And perhaps an examination of that can suggest ways that mediators might change some of the sources of inequity that are seen in the process. Okay, so not everyone thinks that mediation is fair and equitable. Here's a quote from Hasan Batts. And for context, he's an African-American man who is a conflict resolution professional. He served on the staff of a North Carolina community mediation program and on the board of the National Association for Community Mediation. So he's not a stranger to this process, and he did a lot of work with youth in North Carolina. Here's what he said about his experience with mediation. The models we would use were always Eurocentric. They weren't reality-based. They didn't take other cultural perspectives into consideration. I came to understand that mediation is just another tool of oppression, and it's used by the system to meet its needs, especially once the court system is involved. Once the court system becomes involved, there's a power imbalance. And we go into mediation with the goal of bringing harmony, perfection, a balance of honesty. As Dr. Jones taught me, and Dr. Jones is a retired professor who taught him oppression theory, cuss and discuss. We don't allow people to truly put their concerns on the table. Let's hypothesize that Mr. Batts' reaction is a response to what he sees as white supremacy being expressed in the mediation process. I'm not referring to what at first comes to mind by the term white supremacy. I don't mean a racist group carrying weapons and spouting slurs. I'm referring instead to a pervasive attitude in American culture that positions the white as the ideal. White supremacy is more than the idea that whites are superior to people of color. It is the deeper premise that supports this idea. The definition of whites as the norm or standard for human, and people of color as a deviation from that norm. Much more subtle notion, I think, of the basis for white supremacy. This can be seen in Hasan Batts' statement that mediation is Eurocentric. In other words, the white way of doing things is the correct and normal way things should be done. And that extends to communication, the heart of mediation. And let's look closely at his last sentence. Go ahead. In his experience, mediation was denying people voice. Voice, one of the central features of procedural justice. Now, let me describe a few ways that I think this can happen in mediation. One is through tone policing. And here's how Syed describes this concept. A tactic used by those who have privilege to silence those who do not, by focusing on the tone of what is being said rather than the actual content. And here's an example she gives. If you would just calm down, maybe I would want to listen to you. And I think of this as a way to avoid the content of what the person is saying by criticizing their mode of delivery and blaming them for you not being able to hear them. Now, when Sharon and I read this quote, we thought of the ways we had been taught to do things as mediators that could fall into this category. So, for example, many mediators impose ground rules. For example, one person shall speak at a time, no interrupting. Or, will you agree to treat each other with respect? these rules certainly do not encourage cuss and discuss. Now, there are positive reasons to take this approach. It helps the other participant hear, and it can facilitate agreement if that is the primary goal. But what's the potential harm here? Sharon and I worry that this can stifle a person's authentic voice by determining how they must communicate in mediation. So think of the white mediator insisting that a person of color speak in an approved tone. That conveys a message that the white standards are superior and that the individual's voice is inappropriate. And we think, no, go back. I have a good helper here, but I didn't train him in advance. So we think that another aspect of tone policing is curtailing expressions of anger in mediation. There are lots of variations in the way that mediators treat anger, but discouraging it or regarding it as merely venting is not an uncommon approach. Now, this can be seen as justified as a way of avoiding escalation of the dispute. But a Black person's experience with racism is undoubtedly painful, especially in a dispute with a racial edge. Insisting that the discussion be held calmly without expressions of anger can be dehumanizing. And we think that a mediator's perception of anger can itself have a racial dimension. Now, here's another quote from Syed. A white person's expression of anger is often seen as righteous, whereas a Black person's expression of anger is seen as aggressive and dangerous. I think you could draw a parallel here too to women. We're not supposed to express anger either. And the point about anger goes way back to an article about women being required to attend mandatory mediations in divorce. That article made by Trina Grillo made the same point. So would it be more equitable to eliminate these ground rules from the opening statement and just make a rule that we tolerate expressions of anger? There are approaches to mediation that do this, and I would have more to say about them if time permitted. So if you're interested, you can ask me during the questions. But I want to say here that I don't think the solution is that straightforward. In reaction to our article, Isabel Gunning has pushed back on our discussion of tone policing, and she makes the point that respect is really important in mediation. And again, I would be glad to elaborate on this a little bit in the questions if you want. But I think we can say now, at this point at least, that there's something to be said for flexibility on this question, and that mediators could take a more conscious approach to communication and how they're going to structure in mediation to consider the circumstances and the parties rather than just resorting to a standard rule with regard to how the process will be run. And I'd like to ask an even broader question, which is perhaps, should the parties themselves, go ahead, determine the style of communication that is acceptable in the process? Now, self-determination, those of you who have taken the class know it's regarded as a fundamental principle. And the model standards have very broad language about the scope of that principle as involving process as well as outcome. The mediators will often say, oh, the parties are the expert on their interest and on their needs and on the outcome. But I, the mediator, am the expert on the process. And many mediators do not give decisions about process to the parties. And there may be good reasons why. What happens, for example, if the parties can agree on respect, but they disagree on what respect may look like? Might be respectful to interrupt. So a second way, moving on from tone policing, that whiteness is expressed in our culture that I think can also undermine voice is colorblindness. And This is when people profess that they do not notice race. Okay, this sounds innocuous or maybe even wonderful. It reminds me of the goal of Martin Luther King Jr. when he was hoping for a day that when people, quote, will not be judged by the color of their skin, but by the content of their character. But saying that one doesn't see skin color is obviously wrong as a literal matter. And what people are really saying is, I don't treat people differently based on race. But we're still in a society where there are huge differences. There are many race-based inequities, from healthcare to education, wealth, housing, you can go on and on. And so this notion has the effect of erasing BIPOC experience. Now, when I say BIPOC, I'm referring to Black, Indigenous, people of color. It's easier to write than to say, I think, BIPOC. But anyway, Syed calls colorblindness a particularly insidious way for people with white privilege to pretend that their privilege is fictitious when they do not see a difference between their situation and that of people of color. And so it really denies the reality of all these differences that correlate with race. Now, Sharon and I identified 4 different interrelated areas where we think colorblindness potentially shows up in mediation. I'm only going to speak about the first one, blindness to life experience. We also think that mediation can have blindness through racist stereotypes. And there we are thinking about implicit bias on the part of the mediator without their being aware of their bias. Blindness can also be coupled with what Syed calls white silence. And here's where the mediator doesn't react to bias or microaggressions on the part of a party because of how the mediator interprets neutrality as requiring them to not intervene. And finally, we think there is a blindness due to Western cultural assumptions, such as who should be at the table and how do you define the dispute. But I will talk briefly about the first as a place where I think that injecting the idea of equity into the mediation process might make a difference. So mediators are, whoops, go back. I'm missing a slide. That's okay, I'll just talk. We're taught to intervene in a variety of ways that I think can feel like a denial of life experience. The first one is reframing. And that's where the mediator rephrases what a person has said. They often do this in a way to take out the heat, take out the emotion. But so it makes it easier for the other person to hear them, but it's also neutralizing the person's statement and changing their meaning. Another technique mediators use is what we call the "is it possible" question. To encourage someone to broaden their perspective on what happened. And that's by suggesting there might be an alternative explanation here. So for example, you say they did that because they are racist. Could there be another possible explanation? Is it possible? Another technique that's very common is to insist on it being forward-looking, not dwelling on the past. Let's get away from the blame game and let's think about where we can go toward the future. And this does point towards reaching a solution. But we think that insisting on this can also send a signal that the person's experience in the past was not relevant or not important, and that it can be very important for someone to talk about that. And then finally, we know from research that mediators often will shape the narrative. They can do this by something called selective facilitation, by what they emphasize in their questions, by the options that they choose to pursue with the parties. And this often leads a mediator to emphasize what they favor, the options they favor. Often for a good reason. They may judge them to be the most likely to lead to an agreement. But with a white mediator, the white narrative is likely to be the place of comfort and the place that will, the narrative that will resonate with the mediator and the one that they will promote in mediation. So, do these interventions by the mediator that I've just really briefly described, do they ignore, do they even erase the relevance of a person of color's experience with a dispute or a conflict? Especially when one recognizes that mediators are predominantly white. I think you can see how this could be a problem that these techniques can also have the effect of stifling voice. Okay, let me conclude here by underlining a few suggestions on how the process of mediation could become more equitable overall. And these do not originate with Sharon and me, but we think these have merit. First off, we definitely need more BIPOC mediators. We also need, all of us, better education about racist issues and how they can come up in mediation. And I'm not here talking about just a token session with implicit bias as the topic. This needs to be emphasized throughout the curriculum. There are also a number of proposals to use co-mediation. This can diversify the mediator experience and make mediation maybe less directive, more responsive perhaps to what the parties want to do. And we suggest that co-mediation also gives the advantage of you've got someone else there who's seen what happened. And so it could allow a structured debrief that includes asking, was this process equitable today? Was there mediator bias? Was there party bias? How did we treat it? How did it affect the mediation? To bring these questions to the forefront. And finally, I think that there's a really important questions that we need to think about in grappling with a topic that I didn't really touch on today. And that's the tension between neutrality, which is another of the core tenets of mediation, and anti-racist work, and how can they interact more comfortably and effectively. Now, next slide. I've also some suggestions. Whoops, go back. I'm missing another slide. I don't know. It's okay. Technology is wonderful, but I know I put that slide in there. Anyway, okay, so again, you'll have to listen to me. I also have some suggestions about dealing with the potential sources of inequity that we have identified and that I spoke about earlier. One could be, yes, okay, flexibility in how the process is structured. Let's go back to that word flexibility. Avoid the automatic application of techniques. Think about the role of ground rules, anger management, reframing, avoiding the past. Are they appropriate in this mediation? Let's try to look at it from a broader perspective. I think we need to think about those questions within the framework of being responsive to the participants' needs and their goals. Some of these techniques are great because from the sense of they help you get to settlement. But settlement isn't what mediation is always about. And I think we assume too often that it's about settlement and avoid or ignore the broader dimensions that the process can have. And then finally, consider the idea of extending self-determination to the process and putting some of these decisions in the hands of the parties, not necessarily as determined by the mediator. Okay, so note that these suggestions here return to the things I emphasized at the beginning in discussing the origins of the system of equity. Increased flexibility of options and individualized tailoring. Now, what tools do mediators have, short of asking the parties? And they're not going to know. They don't know what mediation is. They may think they know, but not necessarily. And I think that in some ways this goes back to the core function of the mediator of listening. Now, if you go to this slide. And this is a slide that I use when I teach the mediation class in the training weekend for our students. And I use this slide to emphasize that listening is a full body activity. For our purposes here today, in speaking about how to inject equity, I think that the most important is the one at the bottom, using the heart. To be open to understanding is probably the most important for the mediator in promoting equity. Trying to be open to understanding the parties, not making assumptions about them. And so in that regard, I'd like to close, not yet, Bill, with a quote from Isabel Wilkinson. And she's the author of the book, Cast. And by way of introduction to the quote, she believes that those of us who by accident of birth have traits that are highly valued by society and convey privilege, such as being able-bodied, being male, being white. We have a moral duty to develop empathy for those who do not have those advantages. Now, what's empathy? She explains it's not sympathy. Sympathy is the feeling of sorrow for someone, especially if they've had a loss. She adds, empathy is commonly viewed as putting yourself in someone else's shoes and imagining how you would feel. And she says, that's a good start, but think of that as role playing. You're not really experiencing how they feel. And so she calls her what she calls radical empathy. This means putting in the work to educate oneself and to listen with a humble heart to understand another's experience from their perspective, not as we imagine we would feel. Radical empathy is not about you and what you think you would do in a situation you have never been in and perhaps never will. It is the kindred connection from a place of deep knowledge that opens your spirit to the pain of another as they perceive it. Now, mediation, in some cases, seems to me like a great place to attempt radical empathy. And perhaps opening one's spirit to the situation of another might be at the core of anti-racist work. I propose that with a question mark. Not every mediation will achieve this, and not every mediation should even attempt this goal. I think it should depend on the parties. But it is a connection that the mediator can try to forge through radical listening and through questioning, and doing so increase the equity in the mediation process, and perhaps step by step in the world. Thank you. Okay, there are some microphones, and I'm hoping that some of you will have some questions. If not, you know, I could go back to Civ Pro and call on a few people.
Becca has a microphone if someone has a question. There are a few in the chat, we'll also be reading off, but we'll take some from the room first if we have. One question from the chat, Professor Deason, is if settlement isn't the focus of mediation, what should the focus of mediation be?
Well, clearly settlement is one really important focus. And I don't think that these suggestions are mutually exclusive with a settlement on focus. I do think that some of the tendencies that I talked about, the let's get to the future, let's get a solution, let's not get angry, we are in the service of settlement. And I think that that's partly through the connection to the litigation system, and partly because lawyers are so involved as in the role of mediator. So I'm not saying settlement's bad, I'm just saying it shouldn't be the only function. And so, you know, things like repairing a relationship, things like creating a new relationship, those to me seem like worthy goals for mediation. And more radically, could mediation be actually thought of as a technique that would, in some cases, work for anti-racist work, for people to unearth their feelings and explore their attitudes and their assumptions and have a really maybe painful, maybe angry, but deep discussion. That's not the normal, certainly that's not the small claims court mediation, but I think we too often exclude that. Now, you know, those who work in community mediation, those who work in transformative mediation, may be likely to take this broader view of what mediation can accomplish than those who work in the court system, where the goal really is often efficiency and settlement.
Question from Aaron over there. And then there are a number of questions in the chat function, which we'll get to maybe a couple at a time.
So I see that there are these media techniques obviously have the potential to erase people's experiences. Have you seen like quantitative data that kind of backs up that theory, or is the study's not been done?
No, we're not there yet. These are really new ideas. And you know, people have been talking about implicit bias, and certainly the issue of the lack of adequate numbers of mediators who are people of color is a long established issue. But I think that it's fairly new to be applying this framework of tone policing and colorblindness to mediation. So no, we're not, no numbers. Maybe you could do a study.
Great question. One from Professor Lee at the University of Missouri. He asks you to elaborate on your definition or the meaning of culture, as you've used it several times throughout your comments today. Is culture interchangeable with race, at least sometimes, or what are the cultural lines or groups that you're considering in this presentation?
Okay, so I could count on him to give me a tough question. I do think that many people of different races have different cultures that align perhaps with their experience through their race. I think it's, you know, we're not talking about bright lines here, and we want to avoid stereotypes, right? So one thing that we found in our research is there's very little written about African Americans in the United States and their approach to disputes. There's a little bit about Latinx, and there's more, a lot of it assumptions about Asian Americans, but we could use more work on that. So I do think there's a link between culture and race or ethnicity. Now, we've been purposely vague because we're not in the process, we're not in the business of defining that, that distinction. And I think that these ideas really extend, I mean, right now, the most immediate and pressing issues have to do with race, and particularly at the moment with the role of African Americans in our country. Given the history that people are perhaps, I'm optimistic here, beginning to grapple with at the present time. But I think some of these ideas also extend to how should we tailor a mediation program that serves primarily Hispanic disputants? What's the situation when you have a Korean and a Black and a white mediator? And how should we start thinking about these things in ways that go beyond a standard approach to mediation? Does that answer, do you think?
I'll leave it to Professor Lee in the chat to see. If that answers.
Okay.
There are a lot of questions in the chat, but we'll take one from the room. I see Professor Schwartz has a question. And I know we won't be able to get to all of the questions in the chat today, but we'll be certain to share them with Professor Deason so she can ponder them.
Hi, Ellen. What a nice lecture. Thank you so much for being here presenting it. So I was thinking that just introducing a term like tone policing into the mediation discourse is very important, because that tells us a lot about how it can relate to the taken for granted ground rules. And I was wondering if we've begun to think of other possibilities, other concepts. To me, in the gender area, that when I first heard the term mansplaining, I thought, oh, this is a phenomenon that many have experienced, have tried to put into lots of words, but that one word was very helpful. And to me, it connotated condescension, taking up all the airtime, feeling sort of the ability to dictate how the conversation would proceed, the terms that would be used. And I wondered, as you thought about this in the context of race and culture, whether there's something like the mansplaining phenomenon that comes up.
I think there may well be. We have not identified any term. I would add to your elaboration on mansplaining the phenomenon of ignoring what the woman in the room just said. But I do think that the concepts that we have borrowed and the framework that we have borrowed from Layla Said's book of tone policing and color blindness and some of the others that we expound on in our article really helped us think about things, think about mediation differently. So they may not be quite as crisp as mansplaining, but the terminology and the ideas that go along with them really, I think are important. And I see our contribution as importing some of those ideas into the conversation about mediation, where the connection had not been made before.
Thank you, Professor Deason. A number of great questions and comments online. One from a former co-teacher of yours, Erin Archer. I wanted to privilege that question, perhaps, as a former co-teacher. She asks, I know you aren't focusing on solutions, but how do we as mediators develop empathy? The empathy you discussed perhaps at the end of your presentation. And how do we keep empathy from being overwhelming in our work with the parties?
Yeah, I think those are both really good questions. And I think perhaps maybe the next step is to think about how can one learn and become more fluent with empathy, but also to ask, is empathy the right approach here? Because empathy can be exhausting and tiring, and Mediation is already hard work. I see listening as a real key to empathy. Listening with curiosity, listening without judgment, listening to understand, but beyond that, to appreciate the person's circumstances. And to me, that avoids some of the problem of white supremacy of assuming that the one white way is the appropriate way by being open to how others might view the process. Or, obviously these thoughts are not well developed yet, need to leave a little bit of work for other people.
Looking for others in the room. Wonderful. Rivera. Nearby. We'll maybe take one more from online.
Thank you, Professor Deason, for your lecture and for being here today. So you mentioned briefly the tension between the core values of mediation, such as neutrality and self-determination, and ensuring equity in mediation. And I have been doing some research in social justice mediation, and from what I have read so far, I see that theorists do not necessarily see it as excluding core values or equity mediation, but according to them, it is exactly through providing fair and equitable treatment in a way that the parties would think it's fair and equitable that the core values of mediation are preserved. And I just wanted to know more of your opinion about that.
Thank you for your question, Valera. I think that the tension with neutrality comes let me just give you a scenario to illustrate. So let's say you have a mediator and you've got a white disputant and a black disputant. And the white disputant starts spewing vile statements and things that aren't true and things that are disruptive to the process. Now, with a strict interpretation of neutrality, and I don't necessarily think that this is the way it has to be, but there are mediators who think that they have to treat the parties with equidistance, absolutely equal, and that they can't intervene in that situation because it would be seen as them being on the side of one party. So if they call out the white person, they could see themselves as not being neutral in their feelings and in their actions. And of course, the worry with not having neutrality is that how do you have a process if both parties don't trust you? And why would one party trust you if you're on the side of the other party? So I think that we just need a lot of work about what neutrality means and what its limits are, how it actually fits with the idea of equity. We haven't identified equity as a pillar of mediation before. And so I think if we bring it in as a pillar and develop theory about it, we may be better able to deal with your question than I can right now. We do have in the room some experts on neutrality, but
Absolutely.
so.
And boy, I have a question for you about targeted universalism. That's your John Powell gave yesterday, but I'm not going to ask that one. I'll ask you later. Shino Yokotsuka, I'm sorry if I'm mispronouncing it, asks, the field of mediation remains racially and culturally homogenous. Volunteer mediators are those who have the luxury and financial stability and time. For example, economically disadvantaged individuals such as BIPOC persons, often BIPOC persons, do not have the time to engage in mediation, particularly as volunteers. So, Professor Deason, how should we overcome this structural inequality impacting DEI in the field? You have, a minute, go.
Well, that is a big question, and that gets to structures. I mean, I guess I would back up and say we try to focus on structure in the way that people do mediation, as opposed to implicit bias and individual approaches. Both of them are going to be important and both are part of the solution. I also think that this bigger question of structure, of who's doing the mediation, what's fair compensation, is this a profession? What are the consequences of it being a profession? They have so far been to narrow the field. We were very eager to establish our credibility and become professionals. Maybe, this is a radical suggestion, maybe it's time to loosen up on that. It's important to think about what are the standards for certifications and for approval for participation in court mediation programs. Right now, in many cases, it has to do with education. And that, again, that narrows the field in the same way that the question mentions economics as a primary driver. So I have no answer. I don't presume, but I hope that these are questions that the field and people beyond the field can start to think about, not just from the perspective of we need a little more diversity, but from the perspective of we need this process to be one that is embraces equity. And to do that, we definitely need more diversity, inclusion, and equity. So.